he was able to secure a clearance with respect to the criminal cases. And then with respect to the disbarment, they were considered one and the same act by the body. The members of the JBC come from different interests. I represent the retired justices. One represents the academe, one represents the private sector, and one represents the IBP. The government is represented, the Senate is represented by...
Sir, we're aware of the different sectors represented in the JBC, and we are certain that they're all qualified and fit. However, given the cases that were pending, what will happen as a former Supreme Court justice if the Supreme Court decides that no prejudicial question exists and that the Ombudsman should have resolved the Remulla cases on its merits? Do you think that Secretary Remulla can ever be fair in deciding the cases against himself, now sitting as Ombudsman? If he inhibits, do you think that it will allay any notion of partially considering that it is still his underlings who will finally decide? Does that not put us in an untenable position?
Yes, Your Honor, I agree that he has to inhibit himself, but he's in a position to, as the Ombudsman, he is in a position to influence the deputies, if ever, who will replace him if he inhibits himself. But there's so many factors, and we cannot at this time predict what those factors are. But the human factor is very important. Their background, their sense of justice, like that.
Would not that be the same problem if the decision on the two disbarment cases is adverse to Secretary Remulla? How can it be enforced, considering that he is an impeachable officer? Did the JBC not take this into account?
We took this into account, Your Honor. We know that there is a process. With respect to disbarment, sometimes they are directly filed with the IBP, and then it goes to it is referred to the council or the committee in the IBP. And then if they have finding already, it will go to the Board of Governors. And all their findings are recommendatory. It is after the Board of Governors of the IBP, they will recommend to the Supreme Court. The Supreme Court will be the final arbiter.
Yes, Justice Mendoza, we're aware of the process. Merely that it appears that the JBC did not adequately take into consideration all these issues. We are aware, Mr. Chairman and Justice Mendoza, of the tremendous pressure upon the JBC. However, it's apparent that the JBC subverted its own rules and really performed extraordinary leniency in the case of at least two applicants, by which we're totally perplexed and rather alarmed for its future performance. That's all, Mr. Chair. Thank you very much, Justice Mendoza.
Thank you, Senator Amy. Any more questions? Congressman Allen.
Thank you, Mr. Chairman. Justice, may I ask for your view on the use of artificial intelligence in the judiciary? To what extent do you believe artificial intelligence may be permissibly used to aid courts?
Personally, Your Honor, I use lately only AI to correct my grammar. That's all. When I research, I try to research on some issues, but I came to the conclusion that at this time, AI is not yet fully developed for me because I was researching on a case of succession and it provided me with the wrong provision. So I never relied on AI itself. But there are so many uses of AI, and for research, I'm not yet endorsing it. But during one of our interviews, there was a judge who said, he's a judge in La Union, he's a top-notcher, he used AI because the transcript, he asked the AI to summarize it, and the AI summarized it, and according to him, it was very accurate. But we are still, we have in the JBC, we have digitized it already. Applications are online, subject to submission of the hard copies, because what you have submitted, what an applicant could have submitted in the through online may be not the genuine one. So we also ask them to submit a hard copy for comparison. But AI is still limited. I tried it. It's not, still not really reliable. But in grammar and style, it can help. Justice.
Thank you, Mr. Justice. I have no more question.
Mr. Chair, if I may, just Senator Charles. Mr. Chair. I don't think this is AI problem. Mr. Chair, just in that particular topic, just one intervention, if I may. Thank you. Justice, good morning po. Dun po sa framework on artificial intelligence regulation, don't you think it's very important that we come up of a framework on artificial intelligence by coming up with a law that gives framework for our judiciary, Mr. Chair?
Is has embarked on several innovations, foremost of which is the use of AI also. And we have computerized everything in the judiciary, and one of the first to use computers and online is the JBC. If an applicant will apply in the JBC, if he can apply even if he is in Tawi-Tawi or in Batanes, through online, through the ORAS, which is an online registration. It's an acronym, ORAS. And it's very successful, and we have tested it. But we do not automatically disqualify at this time because there are some hitches. But we are trying to solve them. We give the benefit of the doubt to the applicants.
I'm not sure, Mr. Chairman, if we are on the same page here, but I'm not an expert as well. But looking at the current framework, I don't think the courts are in a position right now without having a framework on artificial intelligence, and that's why I'm very interested about this. We're looking at filing a bill in order to address these issues, Mr. Chairman. But anyway, it's
not yet fully developed. But the Chief Justice wants us to study that. we have an office there called BISO, and they're trying to computerize everything, and also AI framework. The Supreme Court has, the Chief Justice created a committee to study that.
Thank you, Mr. Chair. Thank you.
Thank you, Senator Villanueva. Justice, a few questions from the chair.
Is Your Honor.
In the previous rules of the Judicial and Bar Council, those with pending cases or pending complaints are automatically disqualified. The case in point is that case of then Senator, now Congresswoman Laila de Lima. Because of her pending disbarment case in 2012, she was automatically disqualified. But soon enough, your rules were revised, and because of that, under Section 5 of your revised rules, Paragraph B, those with pending administrative cases or complaints before any court, office, tribunal, or government office, agency, or instrumentality, or before the IBP, or any association, disciplinary committee, or body, when in the determination of the council the complaints are serious or grave as to affect their fitness for nomination, ay disqualified lamang po, but again, kung madidetermine ng council na yung complaints are serious or grave as to affect their fitness for nomination. Ang ibig pong sabihin nito, Justice, if the council feels that the complaints are not serious or grave enough to affect their fitness or nomination, hindi po madi-disqualify yung applicant. Is that correct, sir?
With respect to disqualifications, there are automatic disqualifications like if you have been you have pending cases in criminal cases in the courts. And
Yes, Justice.
with
Ang
respect-
sinasabi ko po yung sa Section 5, which
Yes.
says the following are disqualified from being nominated for appointment in any judicial post or the position of ombudsman, deputy ombudsman.
Yes,
Ito pong sinabi ko, pero ang kulatilya po, when in the determination of the council, the complaints are serious or grave. Ibig sabihin po, kung hindi serious at saka hindi grave, hindi po siya madi-disqualify.
po,
That's right, sir.
it pertains to the administrative cases po. If it is pending in the ombudsman, an applicant is automatically disqualified. But with respect to the pending administrative cases or complaints before any office, court, tribunal, or any government office, ito po subject to this discretion of each member. Yun ang
Yun nga po ang ibig ko sabihin,
hindi ho,
Justice.
hindi ho automatic.
Yun nga po. So, ibig sabihin nito dahil nag-file po ng disbarment si Mayor Sebastian Duterte,
Yes po.
ibig sabihin po, in the discretion of the council, hindi siya serious or grave enough. Tama po ba?
Ang what I heard yesterday was the argument that it refers the complaint refers to the same act previously which was in a complaint previously dismissed by the ombudsman or earlier dismissed by the ombudsman. Nag-prevail na reason yesterday. I just cannot disclose the members who gave those reasons, but it prevailed. yesterday. Yes, sir.
This representation, Justice, filed a sworn opposition to the application of Secretary Remulla to the office of the Ombudsman on two grounds. Secretary Remulla publicly announced that he added restitution as requirement to the Witness Protection Program. That requirement does not exist in the law, but he insisted. That justice, to my mind, clearly indicates or demonstrate the lack of required legal acumen as well as adherence to the standards of probity befitting an ombudsman. Second, the Secretary's affirmation of the bending the law constitutes a violation of the Code of Professional Responsibility and Accountability. These two grounds, Mr. Justice, are not enough for the JDC to consider.
It's like this, we receive your complaint or opposition against Secretary Remulla. We considered the reasons, but there were two issues yesterday. First was whether or not he is disqualified. And then doon na ako pumasok sa, because he was not disqualified, he can be voted upon, pumasok na ako doon yung consideration of the merits of your complaint. Doon no, he was not able to get a unanimous vote. Pero hindi ko na ho masabi ko sino yung mga votante. But they considered the reasons you gave. Your two reasons were very important. We received them, we read them, and we considered them.
How did you consider that? How did the council consider the sworn opposition?
Ano yun? Nasa weight na ho yun. Nasa weight. Not sa qualification or disqualification, but on the weight na sa voting ng a considered candidate, nandun na sa weight to yun. The members, majority are appointed by the president. They considered that it is, they voted, the majority voted for him, so they did not give it much weight, you know, or the opposition.
Mr. Justice, one of the overarching principles that guided the creation of the 1987 Constitution is the desire to promote the rule of law, as is stated in our own preamble. Pag sinabi po nating rule of law, this is the guiding post. When somebody affirms that sometimes we can bend the law, or the JBC took that very lightly, Mr. Justice?
No, Your Honor, we, in the interpretation of the law, we can be strict, or we can be, what do you call that? For example, in the interpretation of the Constitution, if you are a strict one, they call you an originalist. And if you want to adapt to the times, they call you are a believer of the living Constitution. I don't know.
We're not interpreting the Constitution, Mr. Justice.
Yes, sir.
I'm asking you whether the rule of law is still the foundation of our Constitution.
It is very much the foundation.
When somebody affirms that the law can be bended, that is inconsistent with the Constitution. Don't you think so?
Yes, I agree with that, but sometimes it depends upon the context of how it is used, the bending of the law, whether it is freely, if they are interpreting it liberally.
Did you know how it was used, Mr. Justice?
Yes,
We were discussing
Yes,
whether
Your
or not restitution
yes, Your Honor.
is a requirement for an applicant to be processed under the Witness Protection Program.
Yes, yes.
And suddenly the Secretary of Justice insisted that one requirement is restitution. It is not there.
aware of that. Your
And somebody suggested that sometimes the law should be bent. That was the context, Mr. Justice.
I heard it, Your Honor. I saw it on
And if you hear it from no less than the Secretary of Justice, abrogating all the cornerstones of our belief in ourselves, in our Constitution, then you still include him as an applicant to the Ombudsman. Somebody who will preside over the lives, the properties and liberties of every citizen of this country. You take light of that. The JBC will take light of that, Mr. Justice.
the majority considered it a slight.
So the majority
The majority
took light of the opposition of a senator of this republic, Mr. Justice.
that is a fact, Your Honor.
And 6 of them, based on their discretion, the opposition is not worth it. Is that it, Mr. Justice?
There were six yes, excluding the secretary himself, because he is also a member of the Judicial and Bar Council.
Because of his inclusion in the shortlist, Mr. Justice, will you favor amending further your rules
Yes, Your Honor.
that would give a chance that all prospective nominees or applicant to the Ombudsman should already be subjected not to the JBC, but the Commission on Appointments?
It's up to you, Your Honor.
It's only a suggestion, Mr. Justice.
But with respect,
Just thinking aloud, Mr. Justice.
yes, Your Honor. With respect to the JBC, we have set tomorrow up to Friday to review and amend the internal rules of the JBC, considering past incidents, and we are inviting the public to submit their recommendations. So it will be a 3-day workshop to amend the internal rules of the Judicial and Bar Council.
What would you think of the public thinking that somebody who affirmed that sometimes we should bend the law has become the Ombudsman of this republic?
I do not have time really to read the social media, but my position is different. I am a believer of the rule of law. I was a justice for several years at a regional trial court. When I was a regional trial court, I adhered to precedents. Also, when I was a justice in the Court of Appeals, I adhered to the precedents. When I was in the Supreme Court, whenever I make a ruling, I was very aware that our decisions will be considered as precedents by those following us. So that's my experience being in the judiciary. That's why I believe in the rule of law.
Thank you, Mr. Justice. Any more questions from the floor?
Mr. Chair.
Yes, Assistant Majority Leader.
Thank you, Mr. Chair. Good morning, Mr. Justice.
Morning.
The Ombudsman position has been vacant since July 27, 2025, and following the retirement of Samuel Martires, with JBC's public interviews concluding on September 2. But the deliberations are repeatedly rescheduled due to composition changes, risking non-compliance with the constitutional mandate of the 90-day appointment deadline, which ends this month, and eroding the public trust amid ongoing corruption probe. Now, my question, Justice, is that the Ombudsman vacancy has lingered beyond the initial post-retirement period, with public interviews that concludes last month. Now the deliberation was almost delayed, and how might such timelines undermine public trust in the judiciary? And in your own view, what procedural reforms should the JBC implement to ensure compliance with the 90-day appointment rule under the Constitution?
In every case, like the Supreme Court Justice, the Constitution provides that the appointment should be within the 90-day period from vacancy. That's why our timeline is very definite. Very well. If we were able, if there was one extension, it was because there was a reorganization in the Senate, and there was a change in the representative of the Senate to the JBC. First, it was Senator Cayetano, and he was replaced by Senator Pangilinan. We have to give Senator Pangilinan time to study what has been happening, because yesterday he appeared for the first time and he voted for the first time. But before that, we gave him all the materials to study because he would be voting. It is the turn of the Senate now. With respect to the rules, Congressman Luistro was there. She participated. She also interviewed the candidates, although only one voted for the ombudsman, because it is now the turn of the senator. But we gave this Senator Pangilinan time to study the candidates. So I think it was reasonable, because there was a change, I think, about, and then it was, I think, originally September 29, because there was, on 19, there was a sudden change. And there was a sudden change of representative. We just wanted Senator Pangilinan to study the matter, because he will vote, and he did vote yesterday.
And the 90-day period, Mr. Justice, would end on what day of this month?
Ombudsman Martires retired. His term expired July 27. So the president has until October 25 to appoint.
Okay. Now,
We were very aware of that. That's why we could not extend anymore, because there's so many complaints we have to study. We have very limited time because of the constitutional constraints. That also goes through with respect to the Supreme Court applicants, 90 days only. And there's so many complaints. We have limited time, because we have some complaints. You need investigators out there to double check, because it is also unfair for the applicants to be automatically disqualified because of a complaint. We must check the veracity of the complaints also.
with regard to the Supreme Court applicants, under Article 2, Section 2 of the clause of the U.S. Constitution, the Supreme Court justices are nominated by the President.
Yes.
And confirmed by the Senate by a majority vote or simple majority of the Senate, emphasizing legislative scrutiny, but often criticized for partisanship and delays, which average of at least 70 days. This contrasts with the Philippine JBC, which is insulated vetting, prompting debates on balancing executive power with checks. Now, the U.S. Supreme Court appointment process involves a presidential nomination, followed by, as I mentioned earlier, the Senate vote, which is a simple majority. What are your thoughts on this model, strengths and weaknesses compared to the Philippine system, particularly in balancing executive decision or discretion with checks against politicization? Mr. Justice.
Your Honor, before the 1987 Constitution, the Philippines had almost a similar system. First, there will be the president will name a nominee, and then he will be subjected to his appointment will be considered for confirmation by the Commission on Appointments, consisting of the members of the lower house and the upper house. In the Supreme Court in the United States, as you have mentioned, it is only by the Senate by a majority. I think, and in the 87 Constitution, maybe it was Justice Palma who was a member, he introduced this concept, it should be, the candidate should be vetted first by the Judicial and Bar Council, and then confirmed by the Commission on Appointments. And then appointed by the President, then but the members are confirmed by, the appointments of the members are confirmed by the Commission on Appointments. I think there is a need. There are pros and cons of those different procedures. I think they have pluses and minuses, but there is a need to study, considering also the Philippine culture, our politics, the people. We are different from the United States. We can adopt it if it will only be the Senate, minus the House of Representatives. My personal view is that the House of Representatives should also be represented, either before or after.
So, considering that this is a very significant decision, as Supreme Court justices have a lasting impact on the society, would you recommend that we should revert back to the old rule wherein their appointments must be subjected to the confirmation of the Commission on Appointments, with the Senate and House contingent being involved?
Did not get the first part, sir.
Would you consider reverting back to the old rule that Supreme Court appointments will be subject to the confirmation of the Commission on Appointments?
Supreme Court. There's nothing wrong with that, because the members of Congress, whether they're senators or representatives, they have different, they can bring their own experience and thoughts in vetting an applicant for the Supreme Court.
Thank you, Mr. Justice. Now, on a lighter note, kayo ho ay dating seminarista.
Yes po.
Pareho tayo. Pero you penned two landmark cases upholding the separation of church and state.
Yes po.
Can you share with us kung ano tong dalawang Supreme Court decision, landmark case that upholds the separation of church and state?
Actually, yung sa The first one is the RH law, sir. Yung RH, I declared that the RH law is not unconstitutional. But there are provisions there which I recommended to be, because as a ponente, you just recommend, subject pa ho yan ng mga agreement, disagreement ng inyong kasamahan. I recommended that they be, because, for example, sa health, if you do not agree with the family planning, you'll be terminated. And that will be against your religious belief, because you do not believe in abortion, you will be terminated. And it was my view at that time, and even now, that he should not be terminated for his religious belief. Ganon, no?
The other case that you planned?
The other case, so, is somebody complained that the whole of justice in Quezon City is being turned into, because the complaint was that it was favoring the Catholic Church and that it should be forever banned, the holding of masses in Quezon City Hall. We denied the petition because we said that providing religious images there that constitute the conversion of the whole of justice into a church. At saka ho yung putting images, religious images there are temporary. After the Mass, those organizers should hide those icons and images from the public view. And any sect or religion can hold the same services. Because in our country, in the preamble of the Constitution, we believe in our supreme God. You can see that in our preamble. Hindi ko lang memoryado ngayon.
We, the Filipino people, imploring the aid of the Almighty God. Thank you, Mr. Justice. Thank you, Mr. Chair. No further questions.
Chairman.
Senator Joel?
Yes, thank you, Mr. Chairman. Mr. Chairman, I actually have a couple of questions here with me, but I can forgo some of it if you are in a hurry, Mr. Chairman. But there's one topic and issue that I'd like to raise. But before that, let me commend our justice for stating the fact that in our preamble we believe in Almighty God. And so, as mentioned by our Deputy Majority Leader, in reciting the preamble of our Constitution, we, the sovereign Filipino people, imploring the aid of the Almighty God. And obviously, we don't need to ask that question, who that God is. But Mr. Chairman, it has been my lifelong advocacy in raising the issue of contract of service, job orders in government agencies and departments. In fact, Mr. Chairman, since I became a member of the Senate, we have been scrutinizing the list of job orders and contract of service in government, while when this representation was the chairperson of the Senate Committee on Labor, we passed the ending the bill. Obviously, because we wanted to address the issue of the evils of end of contract, but it is very hard to advocate initiative because the government is actually the #1 violator of ending endo. I started, Mr. Chairman, there are only about 650,000 job orders, contract of service in government offices. And now it's ballooned to about 900,000. And looking at the judiciary, there are about 12,039 unfilled positions in judiciary, 95.6% in the Supreme Court and lower courts. And this is a factor in the delay of case disposition, I would believe so, and contribute to the 637,919 pending cases in 2024. Now, the judiciary's backlog continues to grow with pending cases rising by 3.5% in 2024. And as I mentioned earlier, 12,039 unfilled positions nationwide, mostly in lower courts, Your Honor. May we know from our nominee, how can the Judicial and Bar Council help in addressing this chronic manpower gap? Would the nominee or Justice Mendoza support perhaps streamlining JBC vetting procedures, or perhaps recalibrating qualification standards to accelerate the appointment of judges, of course, without compromising integrity, Your Honor?
Your Honor, before, we process applications by regions. We thought by regions we can easily dispose of we can fill up the vacancies. Now we have resorted under the leadership of Chief Justice Esmundo. We opened them simultaneously nationwide, from Apari to Hulo to Tawi-Tawi. We simultaneously open. As if there are vacancies, we open them upon recommendation of the court administrator. But there are some newly created courts we just cannot open for application because there are no infrastructures. Courts are created, but there are no automatic appropriations. We have no courtrooms, and we do not have money for the personnel. If you appoint a judge, you have to appoint also a clerk of court, a sheriff, a stenographer, and so forth, and the utilities, a process server. You have to have money for them. And these infrastructures, we have several courts. There are about 80.
Mr. Chairman, I'm sorry, Justice, but I'm talking about 12,039 unfilled positions.
Yes, sir.
Does it mean that there's no funding available for that? Because that's unfilled.
No, the court administrator they are constantly processing all the applications. But there are some courts which are not created. For example, even the Sharia courts, we have a problem. There are Sharia courts in the Barm area, and there are several Muslims outside the Barm area. And then we lack also candidates. For example, we require in the Sharia courts that they be members of the bar. They've already passed the Sharia bar, but most are not members of the Philippine bar. And it is required that they be members of the Philippine bar. There is a bill, I think, sponsored by Senator Padilla, that this be addressed. Still pending. So we cannot immediately fill up the Sharia courts. But we have been informed by Acting Chief Justice Leonen yesterday that they will come up with guidelines so we can open the Sharia courts. But with respect to the regular courts, there is a need to build the infrastructures.
Mr. Chairman, sorry, I really am not trying to ask questions on the Sharia courts and the building of infrastructures, etc., Mr. Chairman. I am more concerned of the unfilled positions, which I believe is already funded, Mr. Chairman. So just to put on record, may we know if the nominee is supporting perhaps the streamlining of JBC vetting procedures, or perhaps, again, recalibrating qualification standards to somehow accelerate the appointment of judges, again, emphasizing without compromising the integrity of the nominees, Mr. Chair.
I am for that, Your Honor. We will expedite it and without sacrificing integrity. And we are doing that. We are publishing the names and the vacant positions, the vacant positions, I mean, and the names like that.
Thank you, because I think it's music to the ears of the employees, present employees of the judiciary, looking at the 12,039 unfilled positions. Now, going back to what you mentioned about Sharia courts, etc., what is your position with regard to the reviewing of BP 129, which this representation believe is already outdated, and the need to integrate Sharia justice system? If you look at the geography of our country and in the situation right now, on how we'll be more responsive in reviewing BP 129, Your Honor?